Our firm represents a lot of people who are charged with failing or refusing to provide a breath sample. Now, that's a criminal offense, and it's basically the same criminal offense with the same consequences as driving impaired or blowing over the legal limit. So when we assess a file, we're looking for defenses and ways and means of winning. And one of them is this. If a police officer observes you on the roadway and observes, say, bad driving, pulls you over and you have slurred speech, red and glossy eyes, you're kind of not making a lot of sense. If they had that constellation of symptoms, they would have reasonable and probable grounds to arrest you for impaired driving. That's sufficient, the evidence that I just provided to you. And you would have to provide a breath sample at the police station into the intoxilizer. If you refused, you would, unless you have another defense, you'd be convicted of refusing to provide a breath sample. Now, here's the key. In order to arrest someone for impaired driving, the police do have to have reasonable and probable grounds. If they don't, you could absolutely refuse to provide a breath sample. That would be a valid defense, a statutory valid defense, and you would win. But the kicker is, police officers don't often make that error. They occasionally do, where they probably didn't have grounds and they should have given what's called a screening test. So a lawyer is going to always, if you phone a lawyer that night, they're always, because they don't know what the grounds are, and the better thing's always to provide a sample. But some clients get lucky. They refuse because they didn't want to, or they're belligerent, and they could win if we could show, for example, the officer saw one slight weave, an odor of alcohol, red and glossy eyes. Well, that person probably has an absolute right to refuse. You would probably win that type of case. But again, you're not going to win the case where there's more serious symptoms like bad driving, more than one weave, slurred speech, unbalanced, that sort of thing. So it is still very much a valid defense, and the bonus is you do not have to file a charter application. Filing a charter application for over 80 cases, by the way, is not working as well as it used to, because a case came out called Grant and Jennings, I should say, and Grant deal with this issue. And they've really limited the exclusion of over 80 cases, but it still works in refusal, and it's a very valid defense. And I recall seeing at least 2 of these cases in our files that came into our office in the last 2 weeks with that valid defense, where the client's going to win, and hopefully the Crown will offer us the careless driving on those matters. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.